Greetings, people, and welcome once again to Cairo, Know Your Rights University. Back at you again with another video that we hope will be educational and informative. Let us begin. Our screen is shared to a document called Condition of Commerce Contract Admiralty Jurisdiction. Let us begin. Edward Mandell House. In 1913, Colonel Edward Mandell House helped to pick the charter members of the original Federal Reserve Board. Edward Mandell House, originally Huis, which became House, was born July 26, 1858, in Houston, Texas. He became active in Texas politics and served as an advisor to President Woodrow Wilson, particularly in the area of foreign affairs. House functioned as Wilson's chief negotiator in Europe during the negotiations for peace between 1917 and 1919, and as chief deputy for Wilson at the Paris Peace Conference. He died on March 28, 1938, in New York City. Edward and his father had friends in the Ku Klux Klan. The Klan dispensed vigilante justice after the Civil War. In 1880, a new legitimate group was in charge of dispensing justice in Texas, the Texas Rangers. Many of the Texas Rangers were members of the Klan. Edward was the new master. Edward gained their loyalty by stroking their egos. Edward would use his money and influence to try and make them famous. Edward eventually inherited the Texas Ku Klux Klan. Edward Mandell House helped to make four men governor of Texas: James S. Hogg in 1892, Charles A. Culberson in 1894, Joseph D. Sayers in 1898, and S. W. T. Lanham in 1902. After the election, House acted as unofficial advisor to each governor. Hogg gave House the title Colonel by promoting House to his staff. Edward wanted to control more than Texas. Edward wanted to control the country. Edward would do so by becoming a kingmaker instead of a king. Edward knew that if he could control two or three men in the Senate, two or three men in the House, and the president, he could control the country. That sort of reminds us of the term that was attributed to, I think it was Amsco Mayor Rockefeller or Rothschild, one of them. Own nothing, control everything. But let us continue. Edward would influence the candidate from behind the scenes. The people would perceive one man was representing them, when in reality an entirely different man was in control. House didn't need to influence millions of people. He need only influence a handful of men. Edward would help establish a secret society in America that would operate in the same fashion, the Council on Foreign Relations. Edward Mandell House was instrumental in getting Woodrow Wilson elected as president. Edward had the support of Williams Jennings Bryan and the financial backing of the House of Rockefeller's National City Bank. Edward became Wilson's closest unofficial advisor. Edward Mandell House and some of his schoolmates were also members of Cecil Rhodes' Round Table Group. The Round Table Group, the backbone of the secret society, had four pet projects: a graduated income tax, a central bank, creation of a central intelligence agency, and a League of Nations. Between 1901 and 1913, the House of Morgan and the House of Rockefeller formed close alliances with the Dukes and the Mellons. This group consolidated their power and came to dominate other Wall Street powers, including Carnegie, Whitney, Vanderbilt, Brown Harriman, and Dillon Reed. The Round Table Group wanted to control the people by having the government tax people and deposit the people's money in a central bank. The group would take control of the bank and therefore have control of the money. The group would take control of the State Department and formulate government policy, which would determine how the money was spent. The group would control the CIA, which would gather information about people and script and produce psychopolitical operations focused at the people to influence them to act in accord with roundtable group State Department policy decisions. The group would work to consolidate all the nations of the world into a single nation with a single central bank under their control and a single international security system. Some of the first legislation of the Wilson administration was the institution of the graduated income tax in 1913 and the creation of a central bank called the Federal Reserve. An inheritance tax was also instituted. These tax laws were used to rationalize the need for legislation that allowed the establishment of tax-exempt foundations. The tax-exempt foundations became the link between the group members' private corporations and the university system. The group would control the universities by controlling the sources of their funding. The funding was money sheltered from taxes being channeled in ways which would help achieve roundtable group aims. Edward Mandell House had this to say in a private meeting with President Woodrow Wilson. Very soon, every American will be required to register their biological property in a national system designed to keep track of the people and that will operate under the ancient system of pledging. By such methodology, we can compel people to submit to our agenda, which will affect our security as a chargeback for our fiat paper currency. Every American will be forced to register or suffer being unable to work and earn a living. They will be our chattel, and we will hold the security interest over them forever by operation of the law merchant under the scheme of secured transactions. Americans, by unknowingly or unwittingly delivering the bills of lading to us, will be rendered bankrupt and insolvent forever to remain economic slaves through taxation secured by their pledges. They will be stripped of their rights and given a commercial value designed to make us a profit, and they will be none the wiser, for not one in a million could ever figure our plans, and if by accident one or two should figure it out, we have in our arsenal plausible deniability. After all, this is the only logical way to fund government, by floating liens and debt to the registrants in the form of benefits and privileges. This will inevitably reap to us huge profits beyond our wildest expectations and leave every American a contributor to this fraud, which will insure us for any loss we may incur, and in this manner every American will insure us for any loss we may incur. In this manner every American will unknowingly be our servant. However, begrudgingly, the people will become helpless and without any hope for their redemption, and we will employ the high office of the president of our dummy corporation to foment this plot against America. From the Congression Record of March 9, 1933, we read, if the Republican Party had released itself from the clutches of Wall Street and expanded the currency immediately after the stock market crash in 1929, or within a year after the crash, our people would have been saved from this awful money panic. Our president will doubtless ask amendments to this new law when conditions are more normal and when it is better understood. Under the new law, the money is issued to the banks in return for government obligations, bills of exchange, drafts, notes, trade acceptances, and bankers' acceptances. The money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. From the case of Jackson versus Bullock, we read that slavery is contrary to the principles of natural right and the great law of love, slavery is founded on injustice and fraud and can be supported only by the provisions of positive law or positions which is not necessary here to prove. The very idea of slavery implies that the slave is one who is in subjection to the will of another. From the treatise Introduction to the Law Merchant by Byron Beers, we also read, it was the concept of a security interest in another's possessions that was innovative and devastating in its results. Under the common law, possession was everything, or, as they say, 9/10 of the law. The law merchant is saying possession means very little if someone has a piece of paper presenting a claim in the nature of a security interest. Some of the English statutes referenced in the quotes above became known as statute merchant and statute staple concerning imprisonment. The following is footnote 46 from the Sheetar's effect on English law. 46. M. Mellon, Restraints of the Person as a Means in the Collection of Debts in Jewish Law. 1961. Preface of Doctoral Dissertation. Jewish tradition had no personal imprisonment for debt, reasoning that if a debtor's home could not be entered, even less could the debtor be taken. In the 13th century, Jewish scholars began to debate and approve imprisonment for evasive debtors, but only in carefully prescribed conditions. Unlike Jewish law, English law specifically envisioned such imprisonment. See Statute of Merchants, 1285, 13 Edward, establishing imprisonment of the body of a defaulting debtor. Statute of Avon Burnell, 1283, 11th Edward. If debtor's goods insufficient to satisfy debt, debtor imprisoned pending repayment, but creditor responsible for assuring bread and water sufficient to sustain life of imprisoned debtor, who must further reimburse creditor upon release. See Statute of Merchants, 1285, 13 Edward, Stat 3. Upon creditor's presentation of debt instrument to mayor, debtor arrested and imprisoned. If he has not paid within 3 months, he is enabled to sell his lands or chattels to satisfy the debt. If he still has not paid in another 3 months, a reasonable portion of his lands and chattels are delivered to the creditor to hold as security against ultimate repayment or until the debt is satisfied out of their proceeds. See also A.W.B. Simpson, Supra, Note 119 at 128 through at 127 through 128. The statute merchant and statute staple were, in themselves, securities. If you acknowledge a debt is due, your mere acknowledgement can be converted into money in an accounting system like the Exchequer in England or Federal Reserve. Statute also sometimes means a kind of bond or obligation of record, being an abbreviation for statute merchant or statute staple. Black's 4th edition, statute. Statute merchant, in English law, a security for a debt acknowledged to be due, entered into before the chief magistrate of some trading town pursuant to the statute 13 F the first, de mercatoribus, by which not only the body of the debtor might be imprisoned and his goods seized in satisfaction of the debt, but also his lands might be delivered to the creditor till out of the rents and profits of them the debt be satisfied. Black's 4th edition. Statute merchant. One of two 13th century statutes establishing procedures to better secure and recover debts by, among other things, providing for a commercial bond that, if not timely paid, resulting in swift execution on the lands, goods, and body of the debtor. These statutes were repealed in 1863. The commercial bond so established, statute staple. If, it is not a little remarkable that our common law knew no process whereby a man could pledge his body or liberty for payment of a debt. Under Edward I, the tide turned. In the interest of commerce, a new form of security, the so-called statute merchant, was invented, which gave the creditor power to demand the seizure and imprisonment of his debtor's body. Frederick Pollock and Frederick W. Maitland, The History of English Law Before the Time of Edward, Black's Law Dictionary, 7th edition. Statute staple. A 1353 statute establishing procedures for settling disputes among merchants who traded in staple towns. The statute helped merchants receive swift judgments for debt, a bond for commercial debt. A statute staple gave the lender a possessory right in the land of a debtor who failed to repay a loan. A popular form of security after 1285 was the statute staple, whereby the borrower could, by means of a registered contract, charge his land and goods without giving up possession. If he failed to pay, the lender became a tenant of the land until satisfied. It later became common practice under the common law form of mortgage, likewise, to allow the mortgager to remain in possession as a tenant at will or at sufferance of the mortgagee. J. H. Baker, An Introduction to English Legal History, Black's Law Dictionary, 7th edition. Commercial bonds are being created by the commercial statutes. Bonds, like all other evidences of debt and promises to pay, are valuable in the current international marketplace. It comes down to the fact that when dealing with the institutions of the great merchants, you really cannot be a debtor because there is no money, and they are not loaning anything they had when you walked in the front door. What they loan is what you create. But if you merely acknowledge the existence of the debt, your acknowledgement is sufficient to create paper to use as money. 26 U.S.C. 7323 states, nature and venue. The proceedings to enforce such forfeitures shall be in the nature of a proceeding in rem in the United States District Court for the district where such seizure is made. This right here is from the IRS website. Warrant of arrest in rem. Number 1. A warrant of arrest in rem is used to seize property for Title 26 forfeitures when the proceedings are civil judicial. Proceedings in rem are governed by the supplemental rules for Admiralty and maritime claims. In addition to the USAO, area counsel must also be consulted so that they can review the affidavit for the warrant. They must also obtain concurrence from the division counsel before a forfeiture action can be initiated. In rem, a technical term used to designate proceedings or actions instituted against the thing, in contradistinction to personal actions which are said to be in personam. An action in rem is a proceeding that takes no cognizance of owner but determines the rights and specific property against all of the world, equally binding on everyone. Flesh versus Circle City Excavating and Rental Corporation. It is true that, in a strict sense, a proceeding in rem is one taken directly against property and has for its object the disposition of property, without reference to the title of individual claimants. But in a large and more general sense, the terms are applied to actions between parties where the direct object is to reach and dispose of property owned by them or of some interest therein. Such are cases commenced by attachment against the property of debtors or instituted to partition real estate. foreclose a mortgage or enforce a lien. Pennoyer versus Neff. In the strict sense of the term, a proceeding in rem is one which is taken directly against property or one which is brought to enforce a right in the thing itself. Actions in which the court is required to have control of the thing or object and in which an adjudication is made as to the object which binds the whole world and not simply the interests of the parties to the proceedings. See also in personam in rem jurisdiction, quasi in rem. In personam, against a person. Action seeking judgment against a person involving his personal rights and based on jurisdiction of his person, as distinguished from a judgment against property, i.e., in rem. Type of jurisdiction or power which a court may acquire over the defendant himself in contrast to jurisdiction over his property. In rem jurisdiction, power over a thing possessed by a court which allows it to seize and hold the object for some legal purpose. Example, boat on which narcotics are found. Calero, Toledo versus Personal Yacht Leasing Company. Quasi in rem, type of jurisdiction of a court based on a person's interest in property within the jurisdiction of the court. There must be a connection involving minimum contact between the property and the subject matter of the action for a state to exercise quasi in rem jurisdiction. Schaefer versus Heitner. Quasi in rem proceedings is generally defined as affecting only interests of particular persons in specific property as against the whole world. Avery versus Bender. In the Fifth Amendment to the Constitution, it says no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. All debts must be attested to under penalty of perjury. From the Propeller Genesee Chief versus Fitzhugh case, we read, the proceedings are in rem, and in substance as well as form a proceeding in Admiralty. It was instituted under the Act of February 26, 1845, 5 Stat at Large, 726, extending the jurisdiction of the district courts to certain cases upon the lakes and navigable waters connecting the same. This power is as extensive upon land as upon water. The Constitution makes no distinction in that respect. And if the Admiralty jurisdiction in matters of contract and tort, which the courts of the United States may lawfully exercise on the high seas, can be extended to the lakes under the power to regulate commerce, it can, with the same propriety and upon the same construction, be extended to contracts and torts on land when the commerce is between different states. And it may embrace also the vehicles and persons engaged in carrying it on. It will be in the power of Congress to confer admiralty jurisdiction upon its courts over the cars engaged in transporting passengers or merchandise from one state to another, over the persons engaged in conducting them, and deny to the parties the trial by jury. Now, the judicial power in cases of admiralty and maritime jurisdiction has never been supposed to extend to contracts made on land and to be executed on land. But if the power of regulating commerce can be made the foundation of jurisdiction in its courts, and a new and extended admiralty jurisdiction beyond its heretofore known and admitted limits may be created on water under that authority, the same reasons would justify the same exercise of power on land. In the case of ABN AMRO Mortgage Group Incorporated versus McGahan, it reads, further, other authorities have stated that mortgage foreclosure proceedings are quasi in rem actions. See R. Waples, Treatise on Proceedings in Rem. Mortgage procedure against property well illustrates a quasi in rem action. Black's Law Dictionary, 714, 5th edition. Defining in rem mortgage as foreclosure of mortgage is in the nature of an in rem proceeding, but it approximates more closely a quasi in rem action. See also 59A, corpus juris secundum, mortgages. 50, corpus juris secundum, judgments. Consistent with the foregoing authorities, we conclude that a mortgage foreclosure proceeding must be deemed a quasi-in rem action. One of the pivotal differences between in rem and quasi-in rem actions is whether the defendant is the property or a named person. See example, Austin 316 at 193, 147 Northeast, 106. In rem actions, the property itself is the defendant, while in quasi-in rem actions, a named party is the defendant. Freeman, 119 U.S. at 187 through 188. In a foreclosure action, the property is not the defendant. Rather, the mortgager, the person whose interest in the real estate is the subject of the mortgage, is a necessary party defendant to the foreclosure proceedings. Mortgager is an indispensable party in a foreclosure action. As such, the proceeding must be brought against a named party, and a foreclosure action must be a quasi-in rem action. R. Waples, Treatise on Proceedings in Rem. It should ever be borne in mind that there are no personal defendants to proceedings in rem. What this treatise is showing is that the law merchant, which is developed by the merchants, is what is governing much of, or possibly the entire legal and political system of the United States. It should also be stated that the legal and political system deal with legal persons as corporate characters using a name similar to the man's name. Some refer to the legal person or corporate name as the straw man. This name also represents a villain or quasi-slave status. There are procedures and processes to use when you understand the difference between you and that in the box name. Also, if one can discharge or set off obligations that may be recorded in the strawman's name, or otherwise control any securities on file in the name of the strawman, you might greatly reduce the law merchant system's charges or demands upon that name. The following information comes from one of the good guys who worked to understand the workings of this altered legal system. Howard Freeman had a conversation with a district court judge who said that prior to 1938, the courts were dealing with public law. Since 1938, they go by public policy statutes. The cases dealing with public law do not apply to public policy. The Erie Railroad versus Tompkins case determined the man struck by a board sticking out from a railroad car could not sue for damages because he had no contract with the railroad. He certainly had a case according to the common law, but evidently not according to the commercial law, including negotiable instruments law. I am going to insert here that sources show Erie Railroad was in the hands of a receiver due to financial problems. Therefore, only the equity side of the court could determine matters concerning Erie Railroad. Also relevant is the possibility that the government of the United States was in bankruptcy or insolvency at the time of the Erie Railroad case. Before the Erie Railroad case, the court in Swift versus Tyson had made decisions according to the common law of the state. So after 1938, there were to be no more decisions based on the common law at the federal level. Also relevant at this time was the blending of law and equity. The courts became merchant law courts and not common law courts. This whole change seems to stem from the bankruptcy or insolvency of the United States, which was stated by another Mr. Freeman conversed with. In 1938, all the higher judges, top attorneys, and U.S. attorneys were called to a secret meeting. According to Howard's conversation with a judge outside the court, the judge was told by certain government officials the following: America is a bankrupt nation. It is owned completely by its creditors. The creditors own the Congress, they own the executive, they own the judiciary, and they own all the state governments. Take silent judicial notice of this fact, but never reveal it openly. Your court is operating in an Admiralty jurisdiction. Call it anything you want, but do not call it Admiralty. The judge stated he would not say more. He probably said too much already. The following court addressed the law merchant. This will serve as a good summary and bring in other facts not covered previously so we can better understand how this commercial system operates. As administered by the king's courts, the rules of the law merchant nevertheless remained a body of law which were applied to particular classes of transactions rather than to a particular class of men. The law merchant thus gradually became a part of the legal system of England. It is true that the process was necessarily marked by mutual adaptation and substantial modification of both systems, that is, the law merchant and the common law. It is nevertheless inaccurate to say that the law merchant lost its identity entirely and became wholly assimilated with the common law when its administration was assumed by the king's court. Though its principles were adopted in the common law by Lord Mansfield, the law merchant still remained a body of rules applicable to a certain class of transactions and an international in character. When we speak of the law of negotiable instruments, we are referring to the law merchant, not the common law. The law merchant, insofar as its fundamental principles are concerned, remained essentially a separate system of law. The law merchant is, in fact, an independent parallel system of law like equity or admiralty. The king's courts administered not local custom nor even the custom of the realm, but rules applied in commercial causes in all countries. It should also be noted that interference by the courts in behalf of the surety as against the creditor for the purpose of accelerating the movement of the latter or of compelling him to take action for the protection of the surety's interests is of equitable origin. Later, the rules of equity were recognized and given effect at law. Their origin and development, however, were entirely distinct and separate from the rules of the law merchant. Our legislature has distinctly recognized the common law as applicable in certain cases in the absence of statute. The negotiable instruments law, however, expressly adopts the law merchant, not the rules of the common law as to matters not covered therein, and this court is required to take judicial notice thereof. This court has held on at least two different occasions that the relations between a bank and a depositor is that of debtor and creditor merely, that the bank is not a custodian of a deposit, but a debtor to the depositor in the amount thereof. The same legislator which enacted the Uniform Negotiable Instruments Law also provided for the codification of all the law of this state and the publication thereof as the revised codes of 1899 under the general supervision of the Secretary of the State. It is a matter of common knowledge that the Negotiable Instruments Act was drafted for the purpose of codifying the law upon the subject of negotiable instruments and making it uniform throughout the country through adoption by the legislatures of the several states and by the Congress of the United States. Bank of Conway versus Starry. Commercial law, a phrase used to designate the whole body of substantive jurisprudence. Example, Uniform Commercial Code, Truth in Lending Act, applicable to the rights, intercourse, and relations of persons engaged in commerce, trade, or mercantile pursuits. See UCC, Black's Law Dictionary, 6th edition. Under 27 CFR, that's the Code of Federal Regulations, 27.11 defines commercial crimes as any of the following types of crimes, federal or state: offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and like offenses, extortion, swindling in confidence games, and attempting to commit, conspiring to commit, or compounding any of the foregoing crimes. Addiction to narcotic drugs and use of marijuana will be treated as if such were commercial crime. From the case of the huntress, we read, in this country, revenue causes had so long been the subject of Admiralty cognizance that Congress considered them as civil causes of Admiralty and maritime jurisdiction, and to preclude any doubt that might arise, carefully added the clause including, etc. Law merchant, taken as meaning substantive law. Aslanian versus Dostumian. Substantive law, the positive law of duties and rights. Cochrane's Law Lexicon, 1924. Related to the substantive social policy embodied in an act of positive law. Bivens versus 6 unknown federal narcotics agents. From the Congressional Record, House, March 17, 1993, page 5321. Mr. Trafficant, speaking to the speaker, states, Mr. Speaker, we are here now in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in world history, the U.S. government. Again, from the Congressional Record, 77 Congressional Record, March 9, 1933, the Emergency Banking Act on page 83, reread, if the Republican Party had released itself from the clutches of Wall Street and expanded the currency immediately after the stock market crash in 1929, or within a year after the crash, our people would have been saved from this awful money panic. Our president will doubtless ask amendments to this new law when conditions are more normal and when it is better understood. Under the new law, the money is issued to the banks in return for government obligations, bills of exchange, drafts, notes, trade acceptances, and bankers' acceptances. The money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. The money so issued will not have 1 penny of gold coverage behind it because it is really not needed. From the Congressional Record, House Banking and Currency Committee before the House of Representatives on June 10, 1932, the 75th Congressional Record, pages 12595 through 12603, we have Chairman Louis T. McFadden stating, some people think the Federal Reserve banks are U.S. government institutions. They are not government institutions. They are private credit monopolies which prey upon the people of the United States for the benefit of themselves and their foreign and domestic swindlers and the rich and predatory lenders. Thank you once again. That concludes our session today. We hope this has been informative and educational, and we look to see you on our next session. Peace and blessings to you all, and thank you once again for listening.